Hello everybody, welcome to today's lecture. Today we will be talking about Chapter 12, the Arbitration Process. If all the other efforts and intentions of solving a dispute or a grievance has not worked well so far between you, the employee, and perhaps union members, then you go through arbitration. As you can see in the outline of this chapter, the topics include types of arbitration, history and legal state of arbitration, arbitration of statutory rights in unions and non-union cases, selecting the arbitrator, determining arbitrability, hearing procedures, case preparation, just cause identification, and arbitration issues in the public sector as compared to the private sector. As we talk about this chapter, think about the fact that today many U.S. employers require their workers and employees to sign employment arbitration agreements which require arbitration rather than the courts to resolve employment disputes. Is this fair, you think, or unfair? Does it tie up the employees' hands when they have to sign something before they even start the job? In 2009, the response to employee rights groups' complaints that such agreements unfairly restrict the rights of workers, the Arbitration Fairness Act was introduced. The act basically would make employment and consumer arbitration agreements invalid and unenforceable. So is it fair to have an arbitration clause right from the beginning when employees being hired? Well, that is the point of discussion for you in reflection for you in this chapter. So what is arbitration? Usually it's a process in which all the parties involved agree to submit their unresolved dispute or grievance to a neutral third party whose decision is usually final and binding. So whose decision is final and binding, meaning we agree that whatever the third party or neutral party decides, we both go with his or her decision. Interest arbitration is a process used to resolve an impasse in negotiations in which the parties submit the unresolved item to a neutral third party to render a binding decision. Rights or contract arbitration is basically the submission to arbitration for the interpretation or application of the current contract terms. So in grievance cases, the arbitration usually involves the rights of the parties involved under the terms of the contract. Demand for rights arbitration is based on the wishes and needs of the parties. Arbitration process is more private than public judicial proceedings. It usually involves more sophisticated and knowledgeable parties than those in most judicial proceedings. To determine when to arbitrate a grievance, there are many considerations. So considerations in arbitrating a grievance could include effect or winning, importance of the issue, merits of the case, psychological or face-saving aspects for both parties, the effects of losing on the one party, and the possibilities for a settlement. Is it high, is it low, or there's no chance for settlement before you arbitrate an issue? When it comes to selecting an arbitrator, the labor and management usually have a hand in the selection and compensation of the arbitrator. Arbitrator's jurisdiction evolves from the collective bargaining agreement. Most arbitrators are selected on somewhat of an ad hoc basis, as long as the two sides agree on his or her qualification. The arbitrator is sort of like the permanent umpire. It resolves disputes for the life of the contract. So he or she helps to provide a stable union management relationship. When we're selecting an arbitrator, there should be some impartiality. Impartial agency is generally the source of arbitrators. that are selected by both union and management members. There are several steps involved in selecting the arbitrator. Number one, at the request of the parties, tribunal sends a list of proposed possible arbitrators to the parties. Step number two, the parties are given 7 days to study the list, cross off unacceptable names, and rank remaining names. Step number three, additional names submitted to parties if no mutually acceptable names are identified at this stage. In step number four, if parties cannot agree on a mutually acceptable name, tribunal will make an administrative appointment. Again, consider the various elements of impartiality, integrity, expertise, and experience in being a neutral third party being part of the process. The role of the arbitrators include the fact that they must follow contract language when the intent of the provision is clear. When the language is ambiguous, arbitrator must interpret the provision in question based on his or her level of expertise, knowledge, and so on. The interpretation of the contract is usually guided by some basic principles, which can include, first of all, honoring the intent of the parties. Second, interpreting the agreement as a whole. Third, give effect to all terms of the agreement. Fourth, give undefined terms somewhat of a reasonable definition. And fifth, the arbitrator should avoid absurd results by considering reason, rationale, as well as equity. Well-reasoned arbitrators' opinion may become part of the contract. The Arbitrators Award is the arbitrator's decision in a grievance case, which is presented usually in a written format, as well as his or her signature on the written document. The qualifications of arbitrators usually vary. Generally, they're not required to have any specific educational or technical training. So they come from a variety of backgrounds based on the level of integrity and trust and obviously experience. So variables that affect the arbitrator selection can include visibility, past arbitration decisions, use of procedural and interactional justice methods. Overall, general qualification of the arbitrator could include being impartial, having integrity, ability and experience and expertise, and legal training obviously is very, very helpful with regards to the local, state, and federal laws of the country where the decision is being made or rendered. There's also the Tripartite Arbitration Board. Tripartite Arbitration Board is an arbitration board that is composed of one or more members that are representing management, as well as an equal number representing the labor side, and a neutral member who serves as the chairperson for this Tripartite Arbitration Board. There comes the question of arbitrability. Arbitrability, the challenge of whether a disputed issue is subject to arbitration under the terms of the contract. If one party challenges arbitrability, courts may get involved. So they may grant an injunction, they may issue a court order to arbitrate, and arbitrability may be considered if an arbitrator's award is submitted to a court for review. Arbitrator can rule on question of arbitrability. There's also the concept of double jeopardy. So it's a concept that is borrowed from criminal law for the principle that a person cannot be punished twice for the same offense based on the same conduct. So we need to keep in mind the double jeopardy concept and do not punish an employee for the same offense twice. The hearing procedures usually include an opening statement by the initiating party, an opening statement by the other side, Third, the presentation of evidence, witnesses, and arguments by the initiating party. Four, the cross-examination by the other side. The presentation of evidence, witnesses, and arguments by the defense. A cross-examination by the initiating party. A summation by the initiating party is usually optional. Also, a summation by the other side is optional. In filing of briefs is also an optional step in the hearing procedures. And finally, the Arbitrators Award is the final step in the procedure. In preparing for the case, make sure to study the grievance statement and review its history. Examine the initiating grievance paper. Review the collective bargaining agreement. Assemble documents. Plan the arbitrator trip to the plant or to the location. Interview all witnesses. Make a written summary of the witnesses' testimony for the record keeping. And study the other party's case. What are they going to argue? And understand it. Overall, discuss the case and do some background reading, obviously, to be prepared. Do consider seniority with regards to promotions and upgrading. Arbitration issues could relate to seniority in cases of promotions and upgrading, layoffs and bumping and recalls, working conditions, discrimination cases, management rights, scheduling of work, or even work assignments. It could include economic wage rates and pay issues. So wage issues and overtime payment could be part of the arbitration process. You can also include fringe benefit issues like health and welfare, the pension plans, other fringe benefit issues that are not necessarily mentioned as part of the contract. You can also include issues of discharge and disciplinary procedures in the department or in the organization. You can have technical arbitration issues like job postings and bidding, job evaluation, job classification, the scope of the agreement, subcontracting, and jurisdictional issues could be part of the arbitration issues. You can also have contractual issues for like just cause. Just cause means sufficient or proper reason for which management has the right to discipline or discharge employees. There should be adequate warning, prior investigation. There should be evidence. There should be evidence of equal treatment of the employee, reasonable penalty, rule of reason, and internal consistency in applying the procedures equally to all employees, whether they're union members or non-union members, and regardless of obviously their age, regardless of their religion, regardless of their gender, and so on. With regards to arbitration in the public sector, keep in mind that interest arbitration violates the principle of bilateral settlement of collective bargaining issues. It discourages parties from making concessions and frequently awards a compromise between parties' final positions. Proponents believe that this is an incentive to negotiate. In rights arbitration, keep in mind that the authority of the arbitrator in rights arbitration is somewhat limited by the terms and conditions of the collective bargaining agreement. So what is arbitration? It's a process in which the parties involved agree to submit an unresolved grievance or dispute to a neutral third party. And that neutral third party's decision will be final and binding. In other words, both parties agree that they will go with that decision, whether it's favorable to them or unfavorable. They will abide by it. In this chapter regarding arbitration, we learn a little bit more about different types of arbitration that is available to you and the employee and the union representatives. So what are the different types of arbitration? There's interest arbitration. So this is the process used to resolve an impasse in negotiations in which the parties submit the unresolved items to a neutral third party to render a binding decision. Rights or contract arbitration requires the submission to arbitration for the interpretation or application of current contract terms. In grievance cases, the arbitration involves the rights of the parties involved under the terms of the contract. There's demand for rights arbitration. Based on the wishes and needs of the parties, arbitration process is more private than public judicial proceedings. It involves more sophisticated and knowledgeable parties than those in most judicial proceedings. As a summary to this chapter, let's look at some tips from the experts. So for arbitrators, what are the 3 most common violations by employers of the just cause provision of collective bargaining? First of all, assuming that the company's rule-making authority abolished the contractual obligation to observe just cause in imposing discipline. It does not necessarily follow that, because a unilaterally promulgated rule is reasonable on its face and uniformly applied, that all the just cause requirements have been met and that penalty is automatically justified. Second, failing to observe an employee's wine garden rights whenever an employee is summoned to an interview with management that he or she reasonably believes is likely to result in a discipline, he or she is entitled to union representation if a request is made. And third, failing to afford the employee procedural due process. This action would include such elements as giving adequate notice of a rule, conducting an adequate and thorough investigation before imposing discipline, and finally, imposing discipline for the purpose of correcting conduct and not necessarily punishing or terminating the employee. So what are the 3 most common errors the unions make in challenging a just cause discharge? First would be failing to screen the facts in circumstances or to assess properly the company's case. Before deciding to proceed with the grievance, the union needs to be thorough in its investigation and assess the possibility of losing or setting a harmful precedent. Second, failing to offer successful post-discharge evidence of rehabilitation. In cases involving discharge for drug and alcohol use, a union can demonstrate to the arbitrator the rehabilitation of the discharged employee. Third, relying on uncorroborated hearsay evidence or bad precedents. So a union should be very careful to screen its evidence for corroboration in its precedent when citing prior arbitration awards to make sure they support the union's position.